Welcome everyone to the webinar. I'm Brian Moore. I'm a partner in the Labor and Employment Law Department here at Dinsmore in Shoal. Joining me today is Associate Esha Simon, also of the Labor and Employment Law Department. We are going to be discussing with you here for about the next 30 to 45 minutes or so, some changes in the world of labor and employment. These changes brought about by various government agencies. I would say exciting changes, except these may not be so exciting changes if you're an employer, and some of these changes may require a lot of time and attention on your part, especially over the course of this summer. Over the next few minutes, we're going to be talking about three different subject areas. One is the new higher salary thresholds taking effect on July 1st, 2024. For certain exempt classifications under the FLSA. Number two, the new rule already in effect, which makes it more likely for individuals to be classified as employees rather than independent contractors. And then finally today we'll talk about the Federal Trade Commission's rule banning most non-compete agreements beginning on September 4th, 2024. We've got quite a bit to discuss, so we'll jump right into it. Of course, we need to draw your attention to a disclaimer here, which basically states this information is current as of June 12, 2024. This is not to be construed as legal advice, but it's information only. And of course, days from now or weeks from now, the information could be outdated at that time. The first thing we want to talk about today is the new DOL rule on overtime exemptions for certain classifications under the Fair Labor Standards Act. On April 23rd, 2024, the Department of Labor issued its final rule increasing salary threshold amounts required for certain employees to be exempt from FLSA minimum wage and overtime requirements. The rule takes effect on July 1st, 2024. So we're coming up on it here in just a few weeks. Keep in mind with all three of these rules that we talk about today, and we'll kind of repeat this several times, they all have legal challenges pending, and we will talk momentarily about those legal challenges. But this new rule proposed, or that's going to go into effect July 1st, according to the Department of Labor, will expand overtime protection to cover millions of additional workers within the first year. And historically, the Fair Labor Standards Act has concerned itself with things like minimum wage, overtime pay, and there are record-keeping requirements for employers under the Act. It applies to private sector employers in the federal, state, and local government. Covered workers are entitled to a minimum wage and overtime for hours worked more than 40 in a particular work week. So there are exempt workers under the Act, and if a worker is properly classified as exempt under the Act, then the provisions regarding minimum wage and or overtime may not apply. A non-exempt worker is someone who is going to be covered by the Fair Labor Standards Act. The overtime protections were established to protect workers from exploitation and to generally benefit workers. According to the Department of Labor, strong overtime protections help the middle class and ensure that workers are not overworked or underpaid. Let's talk a little bit about exemptions. We are going to be focused primarily here on certain exemptions where the salary threshold is going to increase on July 1st. But keep in mind that there are many different exemptions under the Act. Some of the exemptions don't even concern themselves with salary at all. For example, teachers, doctors, lawyers automatically exempt under the Act, regardless of any kind of salary threshold. So the ones we're going to primarily be concerned with here are the executive, administrative, and professional exemptions, where the salary thresholds are going to change as of July 1st. So generally for these people need to perform certain duties, which I'll review with you here in just a moment. And then they need to be paid on a fixed salary basis, which is not subject to reduction due to work quality or quantity. And of course, that salary has to be above a designated threshold. Now, for a truly exempt person under the FLSA, it really doesn't matter how many hours a week they work. They're going to get the same salary regardless if they work 10 hours a week or if they work 80 hours in the week. Again, this is often called the EAP exemptions, but they are the executive, administrative, and professional. They are paid a certain salary threshold. It does not fall above or below a certain amount, and they primarily perform executive, administrative, or professional duties. So let's review those duties. And by the way, this is a common, mistake I often see, which is an employer will say, oh, we're making these people exempt. We're going to pay them a straight salary now, and they're exempt. That alone is not enough. They have to satisfy the duties part of the test. The duties parts of these tests are not changing July 1st. It's only the salary threshold that's changing. So for the executive exemption, they have the primary duty is the management of the enterprise in which the employee is employed, or of a customarily recognized department or subdivision of that enterprise, and they customarily and regularly direct the work of 2 or more other employees. And they have the authority to hire or fire other employees, or whose suggestions and recommendations as to the hiring, firing, advancement, promotion, or any other change to the status of other employees are given particular weight. So you can imagine these people are going to be those fairly high up in management who have all of this authority. The more likely or the most common exemption used is the administrative exemption. In the administrative exemption, these employees do not necessarily have to supervise anyone, but they have a primary duty, which is the performance of office or non-manual work related to the management or general business operations of the employer or the employer's customers. And their primary duty includes the exercise of discretion and independent judgment with matters of significance. So here you could have someone that doesn't necessarily supervise any employees or have members, staff members working below them, but you could have someone perhaps that's in charge of the finances or the accounting of an entity, and they're going to be able to meet this exemption. The last one we want to mention is the professional exemption. The primary duty for these employees is the performance of work requiring knowledge of advanced type in a field of science or learning, customarily with a prolonged course of specialized intellectual instruction requiring invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. And then finally, we want to mention the highly compensated employee test, which this salary threshold will also be changing on July 1st, 2024. This exemption was created a few years ago. And under this one, if as long as the person meets the salary threshold, which as you can see is set a lot higher than the salary threshold for the EAP exemptions, then they only have to meet any one of those duties I just mentioned for any of those EAP exemptions, then they'll be determined to be exempt under the Fair Labor Standards Act. And of course, why all of this is important is because if you misclassify someone as exempt when they should have been non-exempt, then you could be subject to an investigation or a lawsuit and would have to go back and determine whether the amount of overtime that would be attributable to that person. So it is important to have people properly classified because non-exempt employees are the ones that are subject to minimum wage and overtime protections of the Act. Really, you're not going to have any danger or risk trouble if you have people classified as non-exempt, as long as you're paying them correctly and calculating things correctly. The danger area lies, like I said, where we automatically say someone's exempt just because we pay them a salary. You do not want to be found guilty of misclassifying employees as exempt when they should have been non-exempt. Let's take a look at the new rule. Again, this rule goes into effect on July 1st. And note, if you were to pull up this rule in the title of the rule, it mentions outside sales employees. Outside sales employees are those typically who work on a commission basis. They are not subject to the salary test. So only the EAP exemptions and the computer employee exemption are subject to this salary basis test that is changing on July 1st. So the threshold is going to go from about $34,000 a year to $43,000 a year on July 1st. And then it increases more dramatically just 6 months later to $58,656 on January 1st. The DOL has also set automatic increases that will take place every 3 years thereafter. The salary threshold for highly compensated employees is also changing. As we stated a few moments ago, these employees only have to meet one of the duties of the EAP exemption, and so long as their salary is above a certain amount, they're going to be deemed exempt. This one is changing pretty dramatically from $107,432 per year to $132,964 per year, beginning on July 1st, 2024. And then again on January 1st, so just 6 months later, to $151,164. And there's the note about the DOL planning to change these every 3 years. That's part of what people are challenging is that's almost like an automatic rulemaking that the DOL is doing, or kind of circumventing the rulemaking process by having the automatic increases in there for every 3 years. Employers can continue to use non-discretionary bonuses, incentive payments, and commissions to satisfy up to 10% of the standard or special salary level for the exemptions. So what are you to do as an employer? Basically, you have two choices here. One is to move people up. You're going to look at your classifications and see, do I need to move people up in salary? In which place I would imagine that you're going to be seeking to get more production out of those employees to make up for that increased salary. Or are we going to make them non-exempt, pay them on an hourly basis, and then they would be eligible for overtime? And just because someone's eligible for overtime, it doesn't mean that they have to get it. As an employer, you can have a policy that, hey, we don't work overtime here. There's not going to be any overtime available. So there's no right to work overtime. It's just that you have to pay time and a half for it if a non-exempt worker works it. So you'll want to review current classifications to determine who's impacted. And then legal challenges, it's kind of a difficult situation employers are in right now because you have to plan for this change on July 1st. But meanwhile, you want to keep apprised on these legal challenges. There are several going on right now, a couple in the federal district court in Texas. The first one was filed on May 24th, 2024 by the Plano Chamber of Commerce and several business associations. The plaintiffs in that case argue the DOL rule is impermissible because it focuses on the salary portion of the exemption test and effectively eliminates the duties portion of the test. It has requested expedited consideration of the complaint given the impending deadline. The second lawsuit, and by the way, in that first lawsuit, I don't believe there is a hearing pending in that case. But in the second lawsuit, there is a hearing set for June 24th, 2024. In this second lawsuit, the Texas Attorney General has asked for a temporary restraining order to block implementation of this rule, at least on a temporary and then on a permanent basis after that. But there's a hearing set for June 24th, 2024. So it is a possibility that the rule gets blocked at that time. As of now, we have to plan accordingly as if the rule would take effect on July 1st. There's nothing to stop you from notifying employees on a contingent basis that if this goes through, this rule does take effect on July 1st, then there's going to be some changes made. But if it does not go through, then things will remain the way they are. Keep in mind that some state laws, like in California, impose minimum salary threshold that's already higher than that imposed by the new FLSA rule. So keep that in mind. And then before I turn it over to Esha, we will save questions and answers until the end of the presentation and address them there. But with that said, I'll turn it over to Esha to talk about the new independent contractor rule.
Thank you, Brian. So as Brian just mentioned, we are going to talk about the Department of Labor's final rule on employee or independent contractor classification. The DOL first announced this rule on January 9th, and it has been in effect since March 11th, 2024. The DOL first proposed the rule in October of 2022, and for anyone who's interested, they made a full announcement regarding the rule, which is linked below. Previously, Brian had discussed that FLSA, and notably under the Fair Labor Standards Act, there's no definition for independent contractor, but the act does define employer as any person acting directly or indirectly in the interest of an employer in relation to an employee. There are also definitions for employee, any individual employed by an employer, and employ, which means to suffer or permit work. By way of background, next slide, please, Brian. In 2021, the DOL had published a rule titled the Independent Contractor Status under the Fair Labor Standards Act. This test focused on 5 economic reality factors in an attempt to streamline the process. And this was a significant departure from the previous application that determined when a worker was classified as an employee or independent contractor. We'll go over those 5 factors next. So under that 2021 rule, the Department of Labor said to look at the amount of skill required for the work, the degree of permanence of the working relationship between employer and worker, whether the work was part of an integrated unit of production, nature and degree of control over the work, which we'll note will come up again, and a worker's opportunity for profit or loss. Of these 5 factors, 2 were identified as core factors, those being the nature and degree of control over the work and workers' opportunity for profit or loss. And the reason that these 2 factors were determined to be core factors was the DOL took the position that if the 2 core factors pointed towards the same classification, there was a substantial likelihood that it was the accurate classification, and there was no need to further evaluate the other 3. It is important to note that the 2021 rule, which significantly departed from prior legal precedent, never went into effect. The DOL acknowledged and explained that one of the reasons it didn't go into effect was to try to avoid any confusion or a disruptive effect on workers and businesses, because as we mentioned before, all of the legal precedent prior to was not anything like this analysis. So ultimately, had it gone to an effect, there could be a negative impact on both workers and businesses. This new rule that has been in effect since March is a return to the totality of circumstances analysis. And in this new test, economic reality factors are not assigned a predetermined weight, but each one is given full consideration. Under this new test, there are 6 factors that the Department of Labor has outlined. We've listed them here. The first is a worker's opportunity for profit or a loss, investments made by the worker and potential employer, the degree of permanence of the work relationship, the degree of control, which has been a common theme throughout all of the tests, the extent to which the worker performed is integral to the employer's business, and the use of worker skill and initiative. And like I mentioned, this new test looks at all of the factors as a whole and does not highlight any core factors. The DOL has explained that they have some intended goals with putting this new rule into place. The first is consistency with the FSLA. And mainly, which is contrary to the 2021 rule, they're hoping that this rule reduces the risk of misclassification of whether a worker is considered an employee or independent contractor, and can therefore provide a more consistent approach for businesses that engage individuals who are trying to work out which classification that worker will have. There have been lots of commentary about this new rule since it went into effect. The DOL has stated that the rule accounts for social changes and aptly addresses modern work arrangements. In this post-COVID world, there's obviously has been a big shift of remote work and different approaches to the working environment. So given the social context that we are living in now, the DOL is hoping that this rule will provide a more consistent approach. Something to remember for businesses is that overall, this new rule is more favorable to employees. It does make it more difficult for businesses to classify workers as an independent contractor rather than an employee, which is sometimes not in a business's best interest. And any employer who does misclassify a worker can be liable for costs for lost wages, unpaid leave, attorney's fees, and other damages. However, it is important to remember that this new rule does not have an impact on federal, state, or local laws that have distinct criteria for worker classification. Brian mentioned at the beginning that all of these rules that we're discussing today have undergone some legal challenges. Prior to going into effect in March 2024, there have been two notable challenges to this rule. The first was filed in the Eastern District of Texas, and the second one was filed in the Northern District of Georgia. Brian, if you don't mind going to the next slide. However, it is important to realize that although these legal challenges were filed, the rule did go into effect March 2024, and we are currently operating under that rule. The most recent legal challenge in the Northern District of Georgia was shortly after the rule was announced in January 2024. In that case, freelance writers claimed that the new rule forced them to alter their business practices and incurred more costs to remain independent. So they set forth their complaint based on those allegations. Like we mentioned, there are some other independent contractor tests to be aware of. Two that are of note are the ABC test and the IRS test. We'll first discuss the ABC test, and under this, which some states do employ, there are three factors to look at: the extent of the employer's control, whether the work performed is outside the usual course of an employer's business, and whether the worker customarily engages in this type of work. There's also the IRS independent contractor test, which evaluates one's status as an employee or independent contractor. And again, this test focuses on the degree of control. There are three categories that the IRS test will look at in particular. The first being behavioral, second financial, and third the types of relationships. And by type of relationships, we mean if there's a governing contract or if the employee were to receive benefits. And then financial are there business aspects of the worker's job controlled by the payer? And the behavioral is, again, it kind of focuses on the control of, does that company have the control or have the right to control the worker's work and how he does his job or not? Under this, IRS test, The businesses must weigh all of the factors, so it's very important to document how you are going to make a determination of whether an employee is, or whether a worker is an employee or independent contractor. The key is to look at the entire relationship and consider the extent of the right to direct and control the worker, which again was one of the factors in this new rule that went into effect in March. Especially considering that this rule is currently in effect, there are some best practices that you can keep in mind as a business when thinking about how to classify a worker. The number one thing is to enhance the ability to classify a worker as an independent contractor. It is to make sure that the business, that the person has a business license. That would be the easiest way to make them an independent contractor versus an employee. Alternatively, you can also work the 6 factors that we discussed into a contract that you have with that worker. And if there already is an existing contract, a way to get around it would be to do an addendum to that contract and incorporate the 6 factors that we talked about. You can also make sure to look at the degree of control and the opportunity for the individual to make profit or loss. And what that means is if a person is running his or her own business, that person will see a profit or loss versus an employee who will not directly see a profit or a loss. With that, I will turn it over to Brian to talk about the rule on non-competes.
Thanks, Esha. And I'll just touch on the independent contractor thing. Similar with the exempt category, I think what we're really looking for here is, are you just trying to slap a label on something and that's all you're doing? So I'll have situations sometimes where an employer has an employee and they say, well, we want to switch them over to independent contractor. And really the only change they want to make is that we're now calling this person an independent contractor and we're not going to be responsible for workers' comp insurance for them, taking taxes out and things like that. That alone obviously is not enough. Just like I said earlier, you can't just label someone an exempt employee because you pay them on a salary basis and hope that that's enough. It's not. Under both circumstances, with going back to the exempt and non-exempt employees, you've got to look at the applicable regulations, see what the duties are required, and make sure you comply with that aspect of it, as well as the salary aspect of those particular exemptions. And then with the independent contractor, like Esha said, I think the central inquiry is that person, the contractor, really in business for themselves, or are we just trying to put another label on the term employee? So the third thing we're going to talk about today, which has been another hotly debated area, are non-compete agreements. And the Federal Trade Commission on April 23rd, 2024, just recently voted 3-2 to adopt a final rule effectively banning employers from enforcing non-compete agreements. This rule will go into effect on September 4th, 2024. You can expect a lot of debate and there are legal challenges pending. So you'll want to keep apprised of those situations throughout the summer. What is a non-compete? It's defined here as a term or condition of employment that prohibits a worker or penalizes a worker for, or functions to prevent a worker from seeking or accepting work after the conclusion of employment or operating a business after the conclusion of that relationship. Basically, it's considered a restraint on trade historically, or a restraint on competition, I should say. You are, once someone's done working for you, you are in some way restricting where and who they can work for afterwards. Historically, non-compete agreements are going to be governed primarily by state law, so it's going to vary state by state, but similarities among the states are historically these covenants needed to be reasonable in terms of geographic scope. So if I were to put a 30-mile radius on you and say you can't compete with me within that 30-mile radius, That's a lot narrower than if I were to say you're not allowed to compete with me anywhere in the United States. So typically they need to be reasonable in terms of geographic scope. And then as far as time limitations, obviously saying 1 year is a lot narrower than some kind of trying to do a lifetime ban on competition, probably would have been struck down by the courts. And then finally, typically the employer or the business needs to have a protectable business interest. And then the higher the level of employee, the easier it was typically to enforce non-compete agreements. So if you're trying to have your custodians sign non-compete agreements, it might be a little bit more difficult to enforce than it would be for doctors or healthcare providers or things like that. In any event, the FTC says we're going to try to ban all non-competes regardless of title or income level. And the rule is mostly, but not completely retroactive. So this is an important component of it. You can't try to avoid this rule by having all your employees sign non-compete agreements this summer because it's going to be retroactive in nature. And the only exception to that is going to be for senior executives, which are defined here as people making $151,165 in annual compensation and who are in a policy-making position. For everyone else, it's going to be retroactive. The rule will apply to all for-profit companies. It does not apply to nonprofit companies. And also note there are some exceptions under the FTC's jurisdiction. The FTC generally does not have jurisdiction over banks, savings and loans, credit unions, transportation carriers, or communications carriers. If you work or operate in one of those areas, don't jump for joy just yet. You probably want to consult with your legal counsel. For example, while banks and savings and loans may not be covered, holding companies are covered under the FTC rule, or at least that's the interpretation of it from the FTC so far. So bottom line, most employers are going to be covered by this FTC rule. There is an exception for non-compete agreements entered into as part of a bona fide sale of a business. So if I sell my business to someone and I need to sign a non-compete as part of it, that's still going to be valid. Maybe the gray area here is if I have employees and I sell my business, are those employees, can they be covered by a non-compete? A reading of the rule kind of makes it look like as long as it's a bona fide transaction, that the non-competes could be construed, could be enforced against the employees as well of the selling business. However, I'm sure that's an area that's going to be in dispute as well. The rule will also not apply where a cause of action related to a non-compete clause has already accrued prior to the effective date. So if there's already a lawsuit in play, it's not going to apply to that. The FTC's intentions, they say that this will enhance and encourage new business formation. Basically, that will be able to promote competition. We would promote people and employees going out, starting their own businesses, going to work elsewhere, create a rise in innovation, reduce healthcare costs, and higher worker earnings. Definitely, the intent is to benefit employees as opposed to businesses with this rule. As mentioned, you want a familiar court, the federal court in Texas is a popular place to file these types of lawsuits. And I would note, going back to the discussion on exempt and non-exempt, in 2016, the federal court in Texas had blocked a similar rule then. So this is a popular place for people to get some relief as to these governmental rules. In Ryan LLC versus FTC, Ryan LLC filed a lawsuit in the U.S. District Court for the Northern District of Texas, seeking to vacate the rule because the FTC does not have the authority to issue the rule, and the rule is unconstitutional. The court entered an order on May 2nd, 2024, requiring the FTC to respond to plaintiff's emergency motion for an expedited hearing. Another lawsuit's been filed, Chamber of Commerce versus FTC, on April 24th, 2024. The Chamber filed its lawsuit in the U.S. District of Texas, Tyler Division, seeking injunctive relief from the FTC's enforcement. On May 3rd, 2024, the court entered an order staying the proceedings by granting the FTC's motion to apply the first to file doctrine based on the filing of Ryan LLC case. So what do you do now as an employer? You're going to want to look closely at your existing restrictive covenant agreements, determine if that senior executive exception that I mentioned might apply. If so, those agreements can still be enforced. Give notice to non-executive workers, and this is required, who enter into a non-compete clause that the non-compete is unenforceable. This notice must be on paper, delivered by hand, mail, email, or text message. And keep in mind, like with the DOL overtime rule, again, if I had to predict, I would say at least one of these rules is going to be blocked at some point here in the near term, but that's just a prediction. We don't know, so we have to operate under the assumption that the rules will go into effect. I'm going to stop my screen share, and if I'm able to get into the chat and see if we have any questions. And we did have a question about whether the presentation materials will be available afterwards, and that is, of course, true again. Someone asked about the highly compensated slide again, and I can try to put that up if you bear with me. See if there are any other questions first. We can share my screen. Just bear with me. I'll try to go back to that highly compensated slide. Okay. Give me just a second and we'll start it over. Okay, so the current, and let me switch this back. Okay, the current highly compensated test is the salary test is 107,432 as of right now. And remember, just to recap, they only need to meet one of the duties of either the executive, administrative, or professional exemption. And then we'll scroll over to the new salary threshold. It's going to increase from 107,432 to on July 1st, 2024, 132,964. And then on January 1st, 2025 to 151,164. And I think it's really those, I mean, this one's a big jump both places, but with the EAP exemptions, you know, I think employers are looking at not just July 1st, but am I going to be able to afford this January 1st increase? And I think that's the one that's a little dramatic in both cases. Esha, do you see any other questions? I'll stop my share and try to look at the chat again.
We did get one question asking, does non-solicitation covenant apply to non-senior executives?
Yeah, so a non-solicitation and the agreements that are the FTC is attempting to outlaw are non-compete agreements. So saying I can't go compete anywhere. And I'm glad you brought up that question because you can still have non-solicitation agreements. Those are not going to be banned by this rule if it goes into effect. And a lot of times when people ask me about non-compete, what they're really wanting to stop is solicitation. So a non-solicitation agreement is still going to be valid for all types of employees. And basically, it's an agreement that says you're not going to go solicit my current employees, you're not going to solicit customers for a period of time. The other thing that you still can do is a confidentiality agreement. So those are not banned. In a confidentiality agreement says, while I'm working for this employer, I have access to this confidential proprietary information, and I'm not going to use this after I leave employment here. So those types of agreements still perfectly valid. I do not see any other questions, but if you have any other questions, get them in. If not, we thank you for your attention this afternoon. I believe these materials will be made available. So I know there was a lot said and a lot in writing there, but those materials will be available to you. Again, we thank you and hope you have a great afternoon. Thank you.